So what is wrong with you? And she picks you up and brings you back home, and then you beat her up.
He and his attorney walked into court as if it were just another routine hearing, but this case quickly took a darker turn. According to the allegations, after being picked up by his girlfriend and returning to her home, he chose to end the night with a violent assault. Even before the proceedings fully got underway, you could see the judge wearing the unmistakable expression of someone who had already heard more than enough. It's hard not to understand why. The details painted a picture of someone who seemed to believe self-control was optional, and with every moment that passed, the situation only looked worse. Meanwhile, his attorney did his best to remain composed as his client's actions and reputation unraveled in open court. Some people seem to forget that a courtroom isn't a place for excuses. It's where actions are examined and consequences are handed down. Let me know in the comments whether you think Judge Boyd handled the situation well. But first, let's get into what happened.
Is this a plea?
Yes, Your Honor.
All right, can I have a file stamp for a plea, please? Court is calling 2025 CR 0022720 State versus Alfredo Campos. Could I have parties announced?
Here for the state of Texas. Renee Munoz on behalf of Mr. Campos.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Is there an application?
No, Your Honor.
All right. Mr. Campos, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, say we're proceeding. Additionally, Your Honor, say we'll waive the repeat offender enhancement. Also no objection.
All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right. In count 2, you're charged with assault, family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 2. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor. The judge mentioned when we get to the stipulation.
Right. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And you're not allowed to be designated as a primary custodial parent?
Yes, sir.
Right. Knowing that, do you still wish to continue with this plea?
Yes.
Right. Did you review the waiver of appeal paragraph with your attorney?
Yes, sir.
Did you understand it and sign it in both places?
Just take a look at the defense attorney's expression. He seems completely defeated, staring down at the floor as if the answer to his client's problems might magically appear between the tiles. You can almost tell he already knows how this is going to end. The case against his client isn't getting any better, and everyone in the courtroom appears to sense it. The moment Judge Boyd fixes her attention on him, the atmosphere changes instantly. The room grows noticeably heavier, and you can feel the tension building with every passing second. Nobody has to say a word. It's written all over their faces. What makes this situation even more troubling is that this doesn't come across as a simple lapse in judgment. The allegations suggest something far more serious, and that's exactly why the stakes feel so high. Judges are trained to remain calm and impartial, but when a case involves allegations of violence, even the most composed courtroom can feel different. Domestic assault cases sometimes end with negotiated plea agreements, but once testimony, evidence, and the extent of the alleged injuries come into focus, the court's response can become much more severe. At this point, everyone is waiting to see what happens next. Will the judge accept the proposed resolution or decide that a stronger sentence is warranted? Either way, the consequences are about to become very real. For those following the case, this feels like one of those moments where the courtroom stops being a place for excuses and becomes a place for accountability. And if that's where this hearing is headed, the lesson may be about to arrive the hard way.
Did you understand it and sign it?
Yes.
In both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, I didn't.
Then to the offenses charged, how do you plea in count 2? Guilty, not guilty, or no contest? State any evidence?
100% state the evidence states exhibit 1 with all attachments. No objection.
Right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court follow the negotiated plea bargain agreement, Your Honor.
All right. So what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody when maybe she should just let you stay in there, for whatever, and let you just stay there. She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. What's your issue?
I think you should.
Yeah, I mean, you do. Because somebody who, do you love her, or do you claim to love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children, to pay to bond you out, and then, all right, let me tell you what's in the police report, and you tell me what's incorrect about this. I asked victim what happened. Victim stated the following events occurred. Since Wednesday, she went to pick you up from the jail. She stated they were good, no problems. Later that day is when the defendant began to strike and choke the victim. So this is where we are.
I don't know if, I think he just got a little bit tangled up. I don't know if he bonded out or if he was just released at that point, and then she picked him up instead of the bond. I think that's where he was a little confused.
I was just confused because I was released from my stuff, not from the county.
Oh, okay, so there was no bond posted. Okay, that's what I think he was.
So
confused by.
here's my question. Is the reason for this offer because the complainant does not want to participate and has filed an affidavit of non-prosecution? All right. So she's filed an affidavit of non-prosecution, even though I'm looking at the photos. She has a black eye, she has bruises on her arms, and she took time out of her busy schedule to come pick you up from wherever you're incarcerated. So for some reason, she's attached herself to you, but I'm going to try to break that cycle today. So I'm going to sentence you to 3 years in prison. There'll be credit for any time served. There's a $1,500 fine. Time and money is not running concurrently. There's an affirmative finding of family violence. There's to be no contact with Ana Maria Hermio, aka Ana Maria Gonzalez, and you're not allowed to reside in any residence with minors. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed this plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, You're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing. Don't get involved in any other relationship. Don't contact her. If you love her, the best thing you can do for her is not contact her because you're not any good for her. And until you figure out why you feel the need to put your hands on people in anger, you should not be in anybody's relationship. Here's my advice to you. Get an orchid. I always tell people that, and this is why I tell people to get an orchid. An orchid takes a lot of patience. When you get it from the store, it's beautiful. They all have them all with the flowers bloomed on it. They will give you directions. Those directions don't work. I learned you're not supposed to put ice cubes in them. But if you can let the blooms fall off of that orchid and keep that same orchid and get it to rebloom, you may be ready for a relationship because with orchids, you have to learn patience. You understand? All right, good luck to you.
Thank you.
You're welcome.
Just have a seat up there.
What makes this case even more unbelievable is that the woman who picked him up reportedly picked him up straight from custody. At that point, you'd think the warning signs couldn't be any clearer, yet somehow the situation still spiraled into disaster. And then came one of those moments that instantly grabs everyone's attention in a courtroom, when the judge looks directly at a defendant and essentially asks, "What is wrong with you?" That's not casual courtroom banter. That's a sign the court has run out of patience. What really surprised me, though, was the sentence. Considering the allegations and everything that was presented, 3 years feels far lighter than many people would have expected. While Judge Boyd has a reputation for being firm and fair, this outcome is likely to leave some viewers questioning whether justice was fully served. Cases like these often spark bigger conversations because sentencing decisions don't exist in a vacuum. Every ruling influences public perception of accountability, and many people worry that lighter punishments can send the wrong message when serious violence is involved. The reality is that judges face the difficult task of balancing punishment, rehabilitation, and fairness. That's never an easy equation. But when the allegations involve violent conduct, many believe accountability should take priority. It's a reminder of just how much impact judicial discretion can have, with decisions potentially affecting years of a person's life based on the facts presented, the circumstances of a case, and what unfolds inside the courtroom. So what do you think? Does the justice system sometimes go too easy on violent offenders, or do judges generally strike the right balance between mercy and accountability? Share your thoughts in the comments below. Thanks for watching, and I'll see you in the next one.